What you know, Alibis? Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. It's Thursday, July 17th. Hope you guys have had a good day so far. Big hearing in the Bryan Kohberger case today. The hearing was to argue removing the gag order. So let's break down what happened. The state had filed a response that they no longer were objecting to that, but the defense did file an objection stating they do have continuing objections to lifting the gag order. The media attorney, Wendy Olson, said that they understand the defense's concern about the media coverage surrounding Bryan, but they did not think continuing the gag order helps that at all. It limits the media from reaching out to those who know the most about the case, but that doesn't mean anybody's obligated to say anything. She goes on to say the defense also raised due process concerns related to sentencing, but they don't think any of those arguments raised by the defense should outweigh the First Amendment rights of their clients, being the media. Mr. Barlow made arguments for the defense, and he said the publicity is extensive and emotions are already so high that adding fuel to the fire with media interviews or a rush to interview people as they come and go from the courthouse would only increase the concerns the defense has. And even though the plea has a specific sentence attached to it, as the court knows, things can happen at sentencing hearings, and to minimize that possibility, they asked the order stay in place. The judge said at the time Kohberger pleaded guilty, the court was ready to lift the order. The main purpose of the order being put in place was to ensure they would be able to seat an impartial jury, and that is not in play now. He understands the concerns of the defense, but he doesn't think that outweighs the rights of the public to information. He said not lifting the order isn't going to lessen the media attention. It's like water finding low ground, it will flow regardless. Also, lifting the order doesn't require anyone previously bound by it to speak. The state has indicated they will not speak until after sentencing, and he says he hopes the media will give the victims' families as well as Bryan's family space when they are entering and leaving the courthouse without being harassed. And he says the court will have security measures in place to ensure that. If people want to talk to the media, they can. The public rights to information is paramount, so at this point, he can't justify leaving that order in place, especially now that Bryan has pleaded guilty. So what does this mean in lifting the order? The court's preservation order to the parties will stay in place. So what's a preservation order? I looked it up. That is a legal directive requiring a party to maintain and protect specific property, documents, or information that is relevant to a legal case. Also, lifting the order does not unseal documents that were previously sealed by the court. Sealed documents for now will remain sealed. The judge denied the media request to be heard about unsealing everything. He said after sentencing, the court will begin reviewing all sealed materials to decide what can be unsealed and what will remain sealed. The state and the defense will be able to object to unsealing certain documents, and they will also be able to request redactions being made to those documents. The judge will start to review in groupings of documents, likely starting from newest to oldest because he's more familiar with the more recent filings. The judge said this process will take time. He will have to listen to hearings, review content, and he will have to decide if the rationale for sealing is still necessary. And until all documents are unsealed, public records requests will be denied. He said the process is going to take longer than days and possibly weeks, and he asked for patience in the process. However, if both parties do not object to unsealing certain documents, it could go quicker. He points out some documents that contain information protected under Rule 32 pertaining to sensitive content like birth dates, social security numbers, information about minors and the victims, and all other inappropriate information will require review. He said it's unlikely he will unseal much until after sentencing, and the appeals period has run. Now, Bryan Kohberger waived the right to appeal as part of his plea deal, but the United States Supreme Court in Garza versus Idaho made clear that waiving the right to an appeal does not eliminate it. Now, it may affect the outcome of an appeal, but the right still does exist. He wants to let that time period play out first. He will issue an order next week outlining the process for the reviewing of these sealed records, and he will give around 14 days for both the prosecution and the defense to respond to groupings of 1 or 2 dozen sealed documents at a time. And the last part of the hearing, he tells the media attorney, Ms. Olson, if documents remain sealed, he would entertain a request to be formally heard on that, but now it's premature. So he will not entertain the motion right now by the media to unseal everything. So that was it for the hearing. Bryan Kohberger was on screen. If you're on YouTube, you can see him in the top left corner. When these documents start to become unsealed, we will deep dive everything. We will have multiple episodes going over these newly unsealed documents, breaking those down like we always do. But for today, nothing coming out. And in the grand scheme of things, it doesn't look like it's going to be very soon that we start to see any of these roll out. So that's it for today. Hope you guys have a good rest of your evening, and we will see you soon.